The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your bi-weekly-ish podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by Robert Everett Johnson and Ricard Poach Kanawala. If you like what you hear, you may be interested in the Short Circuit newsletter, a weekly email roundup of cases of interest. Go to ij.org/short-circuit to subscribe. This week on the show, Dr. Evil's pictures of cats, the FAA's drone registry, Trump's travel ban, and cell phone surveillance. But first, a brief interlude from Robert Everett Johnson.
Yeah, so we had fun listening to a clip from an oral argument the last podcast, so we thought we would try that again. This one comes out of Georgia, and it's a transportation case. It's not an IJ case, but it's in the realm of things that IJ does. And as you can tell from the clip that we're going to play, IJ's litigation played a huge role in the case and at the oral argument. So this is a case about what happens when a state deregulates the taxi industry. In Georgia, you were required to have basically what's called a medallion from the government in order to run a taxi cab.
They call it a CPNC in the clip, but it's a medallion, basically. Permission to operate a cab.
It's a certificate of public necessity and convenience, which basically means you have to get the government's permission in order to have a cab. And the state of Georgia deregulates the taxi industry, says, well, you can still keep these medallions. You can hang them on the wall. They look pretty, but you don't actually need one in order to run a vehicle for hire. So this is basically opening the market up to Uber and companies like that. And so the question is, well, you've got all these people who have these medallions that had monetary value because they conferred a monopoly, and suddenly the value of those medallions has been destroyed. And these medallion owners come to court and say, oh my gosh, you took away our government-granted monopoly. This is like our property that you've taken away from us. And you can hear in the clip what the court makes of that argument.
And not only has property been taken away, but they need to be compensated for the loss of their property.
And that may sound reasonable. Generally, if people have something taken from them, we think they should be compensated. But here, the thing that's been taken away is not something that they built with their own two hands, like a house or a business or something like that. What's been taken away from them is a government-granted monopoly. And so they still have their taxi business. They can still do business. They just can't keep other people out of the market.
One way to think about it is that they've been granted a government-issued license, and they still have that license. They can still operate their company. What they can't do is use that license to keep other people from similarly operating and competing with them.
Right, and we can't. The problems that would arise is if you accepted this argument that the ability to exclude other people from the marketplace is a kind of property interest that the government can't take away from you. That would take these government-granted monopolies that are so bad, that are excluding people from exercising their right to earn an honest living, and it would not only perpetuate those monopolies, but it would turn those monopolies into something that is protected by the Constitution, and that the government not only has, are these unconstitutional monopolies going to stick around, but you can't even take them away if you want to, because then you've somehow taken away people's property, and that just can't be right.
And there's also a consumer aspect to this too. We look at it from the perspective of other people wanting to compete with these medallion holders, but there are also consumers who benefit from the increased competition. There's increased service, lower prices, more flexibility, and that's something that has to be taken into account too. And I think that's something that the courts are thinking about.
Yeah, that's exactly right. I mean, the bottom line here is the right to prevent other people from earning an honest living is not a property interest. It's protected by the Constitution. So why don't we hear the clip?
This is an issue of first impression before this court regarding CPNCs.
But not first impression before courts around the country. Do you have a single one that's come out your way?
We don't have a single case that's been decided on Georgia law.
But all the cases involving this issue under
all of the
state law
cases,
and under the federal Constitution.
That's correct. And this case is brought under the state Constitution. First of all, the difference being in the Georgia Constitution, it allows for a taking claim based only on damage. There doesn't have to be a complete taking of the property.
That's true under the federal Constitution and most state constitutions, too.
So if it wasn't clear from that, what we were listening to was the attorney for the taxi cab medallion owners, who's basically being asked by the court, what cases support your position, and the answer is, well, no cases. And the sort of background on that I think is important, worth bringing out here, is that there are a lot of cases that have litigated this question, including almost all of the cases, ones where the Institute for Justice was part of the case. We entered as interveners on behalf of people who wanted to provide taxi cab services without owning a medallion. And in all those cases, we won. And so there's an Eighth Circuit case from 2009 that was argued by IJ's now president, Scott Bullock, and then another case from last year from the Seventh Circuit. And both times we won. And both of those cases, the Georgia Supreme Court's decision just came out last week, and it cites both of those decisions. So really what you hear in this clip is the impact of IJ's work in the transportation area, even when we're not in the courtroom, when somebody else is the one litigating the case. It's our precedents, the precedents that we've set, that are driving the result.
Okay, let's move on to the first case of the day, which comes out of the Sixth Circuit. Ricard, kick us off.
This case, U.S. versus Brown, is a Sixth Circuit case, and right off the top, I agree with the court's decision here, but I take issue with its disparagement of the Austin Powers movie. The court says that when criminal law imitates art, it's not the highest form of the art. Anyway, the defendant Brown adopts symbols from the Austin Powers movie's character, Dr. Evil, in his attempt to extort $1 million from the accountants, PricewaterhouseCoopers, and the Republican and Democratic parties of Williamson County, Tennessee. And this is to prevent him or have him release then GOP nominee Mitt Romney's unreleased tax returns that Brown claims he stole from PwC. So using the nom de guerre Dr. Evil in his demand letters, Brown also used an altered image of the Dr. Evil character wearing a Secret Service badge in the lobby of PricewaterhouseCoopers offices in Tennessee. So PricewaterhouseCoopers does an investigation. They find no records have been stolen. The Secret Service then investigates using the flash drives that were sent to PwC and the political parties and demand letters, and discovers a digital trail, email addresses, online usernames, IP servers that were accessed, leading to the defendant's house. So they obtain a search warrant, and the search reveals more incriminating evidence at the house. The same misspelling of advice as advise in the demand letters, a file with the defendant's wife's name on it on the flash drives that were sent, internet logs to the same anonymous IP server, and importantly, pictures of the defendant's neighbor's cats that were also on the flash drive. So on the basis of all of this evidence, the defendant's ultimately convicted of 12 counts of wire fraud and extortion, sentenced to 4 years in prison and $200,000 in restitution to PwC. So the issue before the Sixth Circuit is whether the trial court erred in denying the defendant a Franks hearing. This is from Franks versus Delaware, and it's a hearing where the defendant has a chance to argue that the court should suppress the evidence from the search of his house because law enforcement used false statements in the affidavit to obtain a warrant.
Yeah, and really what he's saying here is that there were this affidavit that they used to get the warrant had a pretty bulletproof case where, we found his email address in the flash drive, all the various things that Ricard mentioned, this sort of trail of breadcrumbs leading back to him. And he just says, well, here are some little inaccuracies that were in the warrant application. And based on those inaccuracies, you should throw out the warrant, and you should say that all this evidence that came afterwards was illegally gotten. And the court basically seems to be saying, even if we made all the changes that you suggest, the trail that you left behind you, and the sort of, I think the court's opinion almost, I don't want to say contempt, but it almost drips with contempt for this guy. But it's sort of like amused contempt. Like they think he's sort of like Dr. Evil.
Yeah,
he's so inept that it's funny, right?
Yeah, he's no master criminal.
The trail of breadcrumbs was just there were so many breadcrumbs that inaccuracy in the warrant was just completely irrelevant.
I think that's all correct, and that's pretty much how the court goes about it. The only part of the decision that does give Brown some hope is that they actually vacate the sentence because they say that the obstruction of justice conviction wasn't well founded.
And this is actually my favorite part of the opinion. His explanation for, how did all this lead to him? And, he says, I'm innocent. Somebody else must have broken into my house and used the computer. And he actually tells the Secret Service, at one point I saw 2 black guys in my house using my computer, which is just like one of those things. It's like whenever a criminal gets caught, they always just blame it on an unidentified black man who. But anyway, so the obstruction of justice thing was, for trying to obstruct justice by lying about these men using his computer. And the court basically says this was so preposterous and no one was going to believe it that it didn't really have any impact on the investigation. And you can't sentence him to extra time in jail because of it.
And also, the court says that the defendant was responding to investigators' questions about who else had access to the house. So whether it wasn't clear whether those 2 individuals were actually on the list of people who were at his house,
or if they ever existed,
or if they existed. So if they never existed, then it couldn't be obstruction of justice. And if they did exist and were their names were put on the list, then he was responding to an investigator's request for information. So that was an obstruction of justice.
Okay, let's go to the next case, baby.
Yeah, baby.
All right, so the next case is a little bit more of serious fare. This is the travel ban case out of the Fourth Circuit. I don't think the facts are any mystery to anybody who's listening. President Trump, in his first week in office, enacts this travel ban on numerous countries. It gets struck down. He reenacts it, or it gets enjoined. He reenacts it. And the case is now wound up in the Fourth Circuit. And the question is, does this travel ban violate the Establishment Clause? Or at least is there a sufficient case that it violates the Establishment Clause that it should be preliminarily enjoined while the full case winds its way through the court system? And I think, look, I don't think we need to get into the sort of merits of this. It's been discussed ad nauseum online, in the blogs, on Twitter. I think, I obviously have my own personal opinions about this. I think everybody has their own personal opinions, but that's not why we want to talk about it. What we want to talk about is how this case relates to this idea of deference, the standard of review, and judicial engagement that we talk about on this podcast constantly. Because really the sort of government's argument here was, well, you don't really have to assess whether the travel ban is constitutional or not constitutional, because in the area of immigration, the government can basically do whatever it wants, and judges should just not ask if this is constitutional or not. And to some extent, you might say that the lawyers here were doing the president and the administration a disservice because they didn't really argue, it seems, that this is something that is justified by any sort of serious policy argument. They just argued, sort of deference. And maybe they did that because deference always seems to work in cases with the government. But here is an example where it didn't, because the Fourth Circuit basically said, we're not going to defer. We're not going to just close our eyes. And the Fourth Circuit sort of rolled up its sleeves. And the conclusion they drew was that this travel ban violates the Establishment Clause.
What I'd say about this case is really it's the exception that proves the rule in terms of courts really not doing the kind of work that the Fourth Circuit does here, which is really going through the evidence, piecing through it, pulling apart statements, really looking at what is going on in the underlying below the surface, and that's really what needs to happen in other cases. If you take just one paragraph of the court's decision and look at it and just substitute out secular purpose and read in rational basis, that gives you a sense as to what the court's doing here that they don't do in economic rights constitutional cases. So here's the quote, page 55 from the majority opinion. It is nonetheless the duty of the courts to distinguish a sham rational basis from a sincere one. The government cannot meet this requirement by identifying any rational basis for the challenged action. It would leave the purpose test with no real bite, given the ease of finding some rational basis for almost any government action. Rather, the government must show that the challenged action's primary purpose is rational.
Yeah, I mean, I think that exactly hits the nail on the head. And really what's sort of interesting about this is, like the rational basis area in economic liberty, this is an area where there's a lot of Supreme Court precedent saying that you just roll over and defer to the government in every case. I mean, there's like a whole line of cases that say this. And what this decision shows, I think, is that, courts defer when they want to defer. And, there are a lot of people out there who think, like this idea of deference and judicial minimalism is going to mean that judges aren't going to, make decisions. And really the answer, that's not true, right? If judges want to defer, they'll defer. But what this case shows is that a whole line of decisions saying defer, defer, defer. Well, if the court doesn't want to defer, they're just not going to defer. And if the government attorneys come in and they make this deference song and dance in a case where the court doesn't want to defer, the court's just going to roll right past that. And conversely, I think it shows that when courts say that they're deferring, what they're really doing is they're deciding on the merits. They're just using deference as an excuse. And so there's really no way around this idea that judges are going to judge. And, I think there's a lesson there both for judges, which is, you really just should, if you're going to judge, you should judge honestly and say that that's what you're doing. And there's also a lesson for litigants, which is it can be very dangerous to just rely on deference above everything else, because if you don't convince the court that you're right on the merits, deference isn't going to win your case for you.
Yeah, there's no question that you have to have something in addition to deference, even if you are arguing it, and particularly, as I think you were alluding to, particularly when the stakes are high, there's going to be more scrutiny of the facts, of the evidence, of the record, and you have to build that record and be able to point to items in that record that bolsters your argument. And even if your argument is essentially in the national security immigration area, deference is what should win the day. There still has to be something on top of that.
Okay, let's move on to the next case, which comes out of the Fifth Circuit. Ricard?
Yes, this is U.S. versus William Wallace. So I think of this as the Braveheart case. On information from a confidential informant about the location of a fugitive, government investigators obtain a ping order to get information to locate the defendant through his use of a cell phone. And the ping order allows the government to obtain cell site location data, and that's how they find the defendant in this case. There's no actual warrant for that. So the defendant's located, and he's ultimately convicted of a breach of probation for having a firearm, which he's not allowed to have by his probation conditions. And ultimately, he's also convicted for aiding and abetting retaliation against a witness by posting a picture of the alleged snitch, the confidential informant. So the defendant alleges that on appeal that the trial court erred in denying his motion to suppress evidence from the ping order because it didn't meet the statutory requirements. But as the court points out, the statute provides the exclusive remedies if the ping order is wrongfully obtained, and that doesn't include suppression of the evidence. So even if the defendant's right on that allegation, it doesn't help him in terms of overturning his conviction. So the defendant then alleges that the search was a violation of the Fourth Amendment. And the issue is, did the government, in obtaining future or prospective cell site location data, violate the defendant's subjective expectation of privacy that society regards as reasonable, which is essentially the Fourth Amendment test on that. And the Fifth Circuit holds no. So the trial court did not err in considering the evidence, and that's because, first off, the court says, like past or historical cell site location data, the phone company was collecting this information anyway. Phone companies collect location information and other information as part of their operations for business reasons. And then they were transmitting it, albeit only seconds later, as a business record to the government. So the court, relying on Sixth Circuit precedent, says no, there isn't a subjective expectation of privacy that's reasonable here. And the Sixth Circuit says that that the Fifth Circuit relies on, that if criminals are using this technology, then they can't complain when that technology is used against them. We can return to that in a minute. The second part of the holding is that there's also a good faith exception to the exclusionary rule, which applies here, and that says that if police act objectively in an objectively reasonable manner on a statute, then the evidence obtained through that statute isn't excluded, even if if the statute, the law, is ultimately found unconstitutional. And that's because the policy focus in this area on Fourth Amendment jurisprudence is on deterring the police from knowingly violating the Constitution and not on returning a victim to the place they would have been in otherwise.
So it seemed to me reading this that this basically turns on something we've talked about before, which is the third-party doctrine. And this is probably right now the biggest issue in the Fourth Amendment law, is this question of what happens when you have information that the government doesn't have. It's private from the government, but you're sharing it with some sort of corporation that is providing you with the service. And this came up first in the 70s with bank records, and there was this whole question because the government passed what's called the Bank Secrecy Act, which is something we've actually litigated about at IJ in a number of cases, the structuring cases. But without getting into all of that here, basically your bank reports, your bank records are not private. If you make certain types of transactions, those get reported to the government. And the question in the 70s when they first set up those reporting laws was, does that violate the Fourth Amendment? And what the Supreme Court said was, look, banking records are not actually private. They're business records that are maintained by the bank. And so requiring the bank to disclose those to the government doesn't infringe on the privacy of the person who owns the bank account. And, that sort of right or wrong was a sort of stable situation. But then more recently, you've just had an explosion of things that implicate this doctrine as we are all outsourcing our private lives to corporations constantly with technology. Think about your email, you think about Facebook, you think about all of the various data that you put online. None of that is on your own computer. It's all on somebody else's servers. We're basically taking our entire private lives and we're giving it over to these corporations. And then the question becomes, well, does that then mean that it's not private? And the same sort of thing arises with cell phones, right? You're basically carrying around in your pocket a tracking device that, if the government was to put it on you, that would violate the Fourth Amendment, but you're carrying it around with you and it's broadcasting your data to Verizon or whoever. And if the government is able to get that data from Verizon, does that mean they haven't violated the Fourth Amendment? And, so under the current Supreme Court precedent, the third-party doctrine, well, you've given this data to this corporation, so it's no longer private. But that is becoming increasingly untenable.
Yeah, I think this case that's an interesting summary of the history. But I think this case really symbolizes how that doctrine isn't sustainable in our contemporary world given technology. I mean, you can think of countless examples where you are providing consent to a third party to get a service, cell phone, internet, even GPS, and that's in order to obtain the service and use the product. But surely that doesn't mean that you are consenting to the government accessing that information, in fact, ordering the company, the service provider, to retain, hold, and transmit that information to the government, specifically to be used against you in a criminal investigation and then prosecution. I mean, if the government can do that across the board, if that's a principle that's upheld generally, then it's really hard to see how the Fourth Amendment really provides any real protection, how it's not hollowed out, because the government doesn't have to go through the whole rigmarole of getting a search warrant and getting the information from you when they can get exactly that information from third-party providers.
Yeah, I mean, this is a doctrine that didn't make a lot of sense to begin with, and it doesn't make any sense today. I mean, this idea that just because you've given information to a third party, that means you've sort of opened it up to everybody, I mean, that doesn't make any sense, right? My wife is in my bedroom. That doesn't mean that everybody is entitled to come into my bedroom, right? My lawyer has access to my legal records. That doesn't mean my legal records are open to everybody. And similarly, my bank has my banking records. That doesn't mean that my banking records are public. I don't want other people to know what's in my bank account. And similarly, I have a cell phone. Verizon knows where I am, but that doesn't mean I want my location to be tracked by the FBI.
How would you have liked the government to behave in this case? I mean, you have a wanted fugitive who's, asking for the murder of a snitch or harm to come to a snitch, and he does have this tracking device in his pocket. What would you have liked the government to do here?
Well, you get a warrant. And, in the facts of this case...
Well, they had an arrest warrant for him.
Well, yeah, but you have to get a warrant to use the data to actually track him down. And in this case, maybe that is a sort of ministerial thing that the government has to do. And it's not the facts of this particular case, I think, where this is really significant. But, you go to a magistrate judge and you say, here's the facts that necessitate me getting a warrant to track this person down. It wouldn't be difficult. I'm sure they could have done it. But they didn't do it. And the reason you have to do that is because this is this case, but then there's another case where they're tracking somebody where they couldn't get a warrant, and it's not as obvious. And that's exactly where you need to have the magistrate there to say, when is it like this case where you should be able to get a warrant, and when is it like some other case where you shouldn't?
One other quick point. The code also blurs the lines between past historical data, cell phone location data, and future or prospective data. And they say, well, it's basically the same thing. The phone company is collecting this information, and the government's just asking them to transmit it once collected. But there is a clear difference between the government asking for the phone company for data that the phone company already has collected and retained, and putting the phone company on notice, or any provider on notice, that, hey, you better retain, store, and then give us data on this particular person. There's a clear obligation there, legal obligation, and in fact, a strong influence too, that we're looking at this person and we want you to make sure that you get, hold, and retain that data and send it to us. And I think that also raises privacy considerations and just goes back to the point that we were making about the need for a warrant in these kind of situations, particularly when it's future prospective.
Okay, let's move on to the final case, which comes out of the D.C. Circuit. Rob?
So this is a case about a hobbyist. He's a hobbyist drone enthusiast, and he's also a hobbyist lawyer. He's actually an actual lawyer, but he's litigating this case pro se.
Which means?
Which means that he hasn't hired a lawyer. He's litigating it for himself. So it's a case that comes out of D.C. This guy has a drone that he wants to fly around D.C. He does fly around D.C. And lo and behold, the FAA enacts, the Federal Aviation Administration, enacts a rule saying that all drone owners, private drone owners, must register. You have to sign up with the FAA if you want to. I mean, we're not talking about like drones in the mountains of Afghanistan. We're talking about these little airplanes that you see that are, they're not that big, and they have a little camera on it, and you can fly them around and take pictures.
Within sight of the controller.
Right, within the line of sight of the controller. Yeah. And so you have to register. And the fact that really just jumped out at me is if you don't register, the penalty is that you are a felon. and you could be in jail for up to 3 years, which is just, I think, maybe registration is reasonable, maybe it's not. I tend to think it's not, but 3 years in prison for not registering your model airplane with the FAA. This is crazy.
Talk about overcriminalization.
Yeah, this is just crazy stuff. So anyway, this goes up to the D.C. Circuit. This lawyer, drone enthusiast, litigates it himself all the way up to the D.C. Circuit. And the D.C. Circuit says, it turns out there is a statute that was enacted by Congress that says that the FAA does not have authority to regulate model airplanes. Nonetheless, they have passed a regulation of model airplanes. It clearly violates the statute. It's invalid. It's a pretty simple decision on the merits, but the upshot is drone people are a little more free. You can have your drones and you don't have to register.
The only, and that's correct, the only wrinkle in the case is that in addition to the registration rule, the FAA also has an advisory circular, basically an order, and that says that that drones these model aircraft cannot fly within certain restricted areas within D.C. And the petitioner challenges that aspect too. And you would imagine that it would fall on the same basis as the registration rule, but in fact it doesn't because of a procedural wrinkle, and that is that any challenge to the order has to be made within 60 days. And that wasn't done in this case, and simply because the petitioner didn't know about the order, and so the court says we don't reach that on the merits. So you have kind of this lopsided decision, which really is on the same basis point of law, and should have gone the same way.
So if a regulation goes into effect for 60 days and no notices, that's it. You can't challenge it anymore, even if it potentially.
Yeah, and there's something sort of odd about it, right? That what the court says is, the lawyer, the drone owner says, well, I didn't know about this regulation. And the court says, well, you had notice of it because it was published in the Federal Register, which is, this book where they publish every federal regulation that comes out. And if you were to stack all the copies of the Federal Register, they go well past the ceiling. So the idea that you have notice of everything that goes in the Federal Register is probably a little crazy, but there it is. Who knows? If he was to go out and violate the restriction on doing this in D.C., if Ricard is right that they fall on the same ground, then he should then be able to raise that as a defense. So probably practically the result of the decision is that both things are invalid, but we don't know. Also, the restriction is within a 15-mile radius, so he can always drive out into the boonies a little bit and fly his drone.
So the rule doesn't sound totally crazy, in that you don't want people flying their drones over the White House or various other, national security sensitive areas of the D.C.
Yeah, I think that may well be right. It's an issue that the court, again, didn't reach because they basically said, well, we're not going to reach that because of the 60-day rule. Maybe that's another argument against the 60-day rule, and now we have this kind of lingering uncertainty about something that the court could have cleared up one way or the other.
And you would also think that if the statute directly addressed this, that Congress should have been thinking about those kind of considerations when they passed the law.
Going back to the court's first holding about the registry, I'm curious what the FAA even argued, because you have a 2012 law saying the FAA may not regulate model aircraft, and then they go ahead and they do exactly that. How does the FAA try to justify that?
I think the FAA's argument was they tried to go back in time and say, well, before the 2012 law, we had the jurisdiction to pass rules like this, but we simply chose not to. We exercised our discretion, and so we chose not to regulate them, but we always could. Now, that doesn't directly address your point, and the point here in the case, which is that whether or not they could have before the law, it seems pretty clear that they couldn't once this new law came into effect in 2012. So I'm not sure that the FAA had much of an answer to that. At least there isn't one in the decision.
Yeah, it certainly doesn't seem like they had much of an argument. The court presents this as a very simple case, and perhaps it is.
So there's a lot that remains unsettled, but the upshot is you don't have to register your hobby drone, your non-commercial drone. So that concludes the show. Thank you for listening. Until next time, this is John Ross of the Institute for Justice, permitting you to get engaged.